Once the judgment is pronounced by the Honorable Court, what all remedies are available to the aggrieved party? Today in this video, I will be sharing the remedies that are available to the party who is aggrieved by the judgment. Hi, I'm Mrs. Kritika Singh. It's been over a decade that I have been helping and supporting students to prepare for Judicial Services Examination. We believe that it is just not about cracking the Judicial Services Examination, but it is more about what you become in the whole process of becoming a judge. So, once the judgment is pronounced by the Honorable Court, the party in whose favor the judgment is pronounced, जिस पार्टी के फेवर में वो जजमेंट प्रोनाउंस हुई है, उसको हम कहते हैं डिक्री होल्डर. एंड पार्टी जिसके अगेंस्ट जजमेंट प्रोनाउंस हुई है, उसको हम कहते हैं जजमेंट डेटर. सो जो डिक्री होल्डर है वो एग्जीक्यूशन प्रोसीडिंग्स फाइल करेगा, और जो जजमेंट डेटर है उसके पास सीपीसी के अंदर कुछ रेमेडीज अवेलेबल है. सबसे पहले रेमेडी इज अपील. अपील इज गिवन अंडर सेक्शन 96 to 99A CPC, which is only dealing with first appeal. Section 100 onwards, we have provisions dealing with second appeal. So first appeal is section 96 to 99A, read with order 41 of CPC. So apart from appeal, there are other remedies also available to the aggrieved party. He may go for a review petition. Review means review. If you break this word, review. Re means दोबारा, view means देखना, दोबारा से देखना. आप कोर्ट को रिक्वेस्ट कर रहे हैं कि जो जजमेंट कोर्ट ने प्रोनाउंस की है, आप प्लीज उसको दोबारा से व्यू कीजिए. Review application can only be filed if the essentials of section 114 CPC are being fulfilled. Section 114 CPC is to be read with order 47 CPC. There are no provisions in criminal law which are dealing with review. Review is not a remedy under criminal law. It is just a remedy under civil law. So if the essentials of order 47 read with section 114 are being fulfilled, आप review file कर सकते हैं. Next remedy that is available to the aggrieved party is revision. There is no order under Civil Procedure Code which deals with revision. So 115 is the only provision that is dealing with revision. Where there is no appeal, we file a revision to the High Court. In criminal proceedings, we do have a remedy for revision under section 397 CRPC. The time period for filing a revision application is 90 days, and the time period for filing a review application is 30 days. So the aggrieved party may either go for appeal or for review or for revision after the judgment is pronounced by the Honorable Court. Thank you for watching. For more informative videos like this, you may also subscribe to our YouTube channel, that is EJ Law Academy by Mrs. Kritika Singh.